Hey guys, this is Ben from Level Cut Law. Today we're going to talk about a defense. What is a defense? A defense is a legal document filed with the court in response to a writ of summons and statement of claim. It is part of a set of court documents called pleadings. A defense sets out the facts, and reasons that defendant, the person getting sued, is relying on to say why he's not liable under the claim. Now, the writ of summons is and statement of claim is drafted in paragraphs 1, 2, 3, 4, 5 in chronological order, stating the facts that the plaintiff, the person suing on, is relying for his claim. So, when a defendant issues a defense, he has to either admit to each paragraph, or he does not admit, or he denies each paragraph. What is admit? Admit is saying that it is correct. What is not admitted? Not admitted, that means he is not really sure whether the allegation is true or not true. He wants the plaintiff to prove it in court. When he denies, it means that it is an outright challenge. He's saying that the allegation is a lie. You should only deny if you have proof that the allegation is a lie. Because if you just keep denying everything, just deny, there are bare denials, then the plaintiff can take out an application call and order 14. You can watch one of my earlier videos about order 14 applications. When a defendant denies an allegation in the statement of claim, he should ideally aver his version of events. When you aver something, you are essentially saying something. For example, if the statement of claims says something like, in light of the defendant's breaches of the representations and the defendant's misconduct, parties then entered into a verbal agreement in respect of the following. So that's the allegation in the statement of claim. If the defendant, the person getting sued, disputes that there is a verbal agreement, then he should refer to that paragraph and say, paragraph 14 of the statement of claim is denied in toto. The defendant avers, he says that there is absolutely no truth in the allegation that there was a verbal agreement. And you have to continue averring, the defendant has to continue by averring his side of the story. He could say something like this: on this date, the plaintiff verbally told the defendant that he wanted to exit the investment because it was not making money. The defendant informed the plaintiff that she was not in a position to do this, blah, 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 blah. Some lawyers, at the first part of the defense, they like putting in this clause, say, this defense is filed without prejudice to the defendant's right to strike out the statement of claim, to request for interrogatories, to request for further particulars, blah, 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 blah. That is totally unnecessary. It is one of those meaningless statements like litigation lawyers love to put this statement in their letters. All our clients' rights are expressly reserved. Why? Because just because you filed a defense, it does not prejudice your right to request for further matter and particulars. It doesn't prejudice your right to request for interrogatories, blah, blah, blah. Also, it is important at the end of your defense to include a seriatim clause. A seriatim clause would say something like, save as hereinbefore expressly admitted or not admitted, the defendant denies each and every allegation as if the same was set forth seriatim and specifically traversed. What is traverse? A traverse is essentially a non-admission or a denial. That's called a traverse. It is basically to deny. It's a catch-all, to catch anything that, for example, a lawyer inadvertently, accidentally forgets to deny, so that it makes sure that everything is specifically denied. Thanks for watching this video on the defense. Don't forget to click like and subscribe.